Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
Our guest today is Steve Tarta with Tarta Law, and Steve is an estate planning attorney in Bergen County, New Jersey. Steve, how you doing today?
I'm fine, thank you. How are you?
I'm good. Hey, tell me a little bit about yourself and your firm.
Well, my practice in law started in 1972, and at that time, I really should say 1971, because in 1971 I had finished law school and I wanted to see what happened in the court world, the system. And I applied for and became appointed as a law clerk to 5 judges, actually, in Ocean County, New Jersey. And I worked for 5 judges, and I wanted to see how they made decisions, what happened in the court process. After the 1-year requirement of being a law clerk, I then became a county prosecutor, because my objective at that point was to see what it was like and to develop my skills in the courtroom. And I love being a county prosecutor because it gave me the opportunity to try many cases. I always worked with one other partner, and if that person, my partner, was trying today's case, I would be preparing the backup case of the next case. Thereafter, I really felt it was time for me to get out and really aggressively go into private practice, which I did. And in the beginning of my private practice, by some strange fate, for lack of a better word, I became involved with the automobile industry. And one automobile franchise became 7 over 3 years. So I was doing a great deal of litigation. And during that time, I was brought a woman through an existing client, who needed a basic estate plan. And one thing led to another, and I did this woman's estate plan, and it became quite complex as the following next 3 years passed. And after the 3 years passed, she passed away, unfortunately. But it turned out that her estate was very large, and it encompassed assets in 4 surrounding states. So they don't teach you this subject in law school, and I asked around for someone who I could speak with about the wonderful world of estates and what happened and what you do in it. And I was introduced to a gentleman who had just retired from the Internal Revenue Service. He became my friend, and literally, I hired him to work with me in my office 3 days a week. Since he had just retired, he wanted a part-time job, so it worked out well. He knew the area, and I had this estate, and I became addicted, and that's the only word for it. I became addicted to estate finalization as well as thereafter estate planning. And I had been doing it ever since then. As time passed, around 1992 or 91, I had to make a determination as to what area of the law I was going to practice the most in, because my litigation practice, as I indicated, was very busy, kept me in the courthouse quite a bit, but my clients were calling me at my office, and you had to make a decision. Am I going to be an in-office attorney available to clients, or a courtroom attorney and doing litigation? And I decided to go into and phase out litigation and pursue the estate planning practice. Then that is the history of my history as to my past and how I got into what I do now. And I can say that I firmly love my field, and it gives me the opportunity to meet so many beautiful, wonderful people that really have no obligation to pay estate tax, but don't even know that when I first meet them. And when I explain to them that you really don't have to pay estate taxation, it's very interesting to see their reactions, because sometimes they just say, "Oh, yes, I do. So it's a tax." I go, "Well, you have to pay income tax if you have earned income, but you do not have an obligation to pay estate tax. It's not the same." And it becomes very fascinating, and it's very enjoyable for both the client and for myself once we get to know each other a little bit. So that's how I got into this whole area, and I love what I'm doing.
Yeah, and you found your passion.
I did.
You got lucky and found your passion. So tell me, what is estate planning? What does it include?
Well, estate planning is really the creation of a program, and almost anyone can go online, and they can go on the computer and they can generate a program which would represent the finalization of what happens to them in the event of their death. My feel and my objective in doing estate planning with a client is to find out a little bit more about the individual, because as I said, anyone can create this program as to what happens, but if you really don't understand the individual and you don't really get into what is in their head, how they feel, what their feelings are with respect to, for example, charities or family members, maybe they have a family member that they become distanced from, it really does make a difference. So it becomes a very personalized agenda of creating a program of using techniques to minimize or eliminate totally taxation after you understand where the person's heart, where my client's heart and head really is.
So you really develop a relationship then with the client. You become friends with them.
Yeah, I was just going to say that, actually. I would say the vast majority of my clients do become my friends, really do become my friends, because you do know, you learn and you become very comfortable in knowing some of their most intimate details. And this is really required, and this is what differentiates an estate planner who is doing, hopefully, a good, competent job, as opposed to someone going online just looking for a form or a will, which anyone can possibly do.
Yeah, and so that's where the difference is. Now, when I did a little research on estate planning, I saw some terms, and I'll just go through each one of the terms. Trust. Now, what is a trust?
Well, a trust is an entity or a receptacle. That's the illustration I use in my consultations. It's a receptacle that we use that is aside or apart from you, the individual, and basically trusts are broken down into two formats. One is a revocable trust and one is an irrevocable trust. And each of those formats, those revocable or irrevocable trusts, serve totally different purposes. A revocable trust will not address taxation at all. It is not allowed to address taxation. It never did address taxation, and I feel it never will address taxation. But a revocable trust will address, and is intended to address, reduction of all of your probate expenses, your estate expenses upon death. It is totally revocable. You can modify it. You can amend it. Any assets that you put into it today, because it is revocable, can be removed tomorrow. So there's absolutely no downside or interference with any asset that you place into this revocable trust during your lifetime. And then upon death, that revocable trust does become irrevocable, and it does lay out the procedure of the distribution of your assets to your beneficiaries. Now, alternatively, an irrevocable trust is, as the word implies, irrevocable. You place an asset into that trust, you have distanced yourself from that receptacle. That asset remains in that trust, and in the vast majority of the cases, the federal government requires that asset be placed in that trust for a period of 3 years. There's a statute of limitations, which is 3 years, before the government will acknowledge that asset is truly removed from your estate. By that I mean, if there is a death 3 years after the initial transfer to the irrevocable trust, the government will come in, remove it from the irrevocable trust, put it back into your estate, as if the irrevocable trust was never created.
I see. Okay.
And thereafter, after the 3-year window passes, that asset is totally removed from your name, your estate, and therefore any subsequent taxation. So that is how the irrevocable trust benefits the elimination of or reduction of taxation.
Now, one thing you talked about was probate. Can explain that to me?
Well, probate represents a good explanation of probate represents every and any expense incurred from a moment a person stops breathing until all assets that person owned are distributed to their beneficiaries. So we're talking about the process of submitting a will to the courthouse, to the surrogate's office for their review, approval, and admission to what we call the probate system, the issuance of letters testamentary, which are the appointment letters that designate an individual as the executive or the representative of the estate, and the finalization and the processing of what must happen through the distribution of the assets in that estate.
Okay. A will. Now, what is a will? What happens if I die without a will?
Okay, a will is a document that is intended to specify exactly what your intention is with respect to assets, and not only assets, more than that. Sometimes it will address. I've had people discuss with me, although I don't prefer this procedure. People discuss with me even the what I want to happen with my dog, Susie, upon my death. That's theoretically that's possible.
Sure.
But more commonly, the will really represents the distribution of your assets, from personal assets through real estate to all financial assets to the beneficiaries that you intend them to be. If everything is laid out in that will, one must bear in mind that is a public document. When that is submitted to the courthouse for that probate process, that becomes public. Anyone can go to the courthouse and obtain a copy of the will and see who received what. Many people don't like that. They want to be a little bit more private.
Right.
And therefore the will would not necessarily be the best procedure or document to distribute your assets upon death.
I'm going through a glossary of terms here, but talk about power of attorney. What's that?
Well, the power of attorney is a document it's that I have said for the last 20 years probably is the most underappreciated document in any estate plan, because it is a designation in writing that I appoint you to have the same rights and liabilities that I have during my lifetime. So therefore, if you have the same rights that I have, you can sell my home, my car, you can do anything that I can do. You can sign on any dotted line that I have the right to sign on a dotted line for. Now, there are many types of powers of attorney, but the most common being the durable power of attorney, which is a power of attorney that is not affected by your disability, or by my disability. It remains in effect. And then, again, there's another power of attorney that is referred to as a springing power of attorney. I don't favor that, but it is available, and that is a power of attorney that only becomes effective upon my disability. However, I do discuss that with all of my clients, that there are various types of powers of attorney. I always recommend to my clients if you are willing to give a third party the right to sign your name, they should have the right to sign your name immediately. And over the course of my 40 years of the practice of law, I've had a number of occasions where that power of attorney was very valuable to individuals. And because of that power of attorney, we were able to accomplish some very, very good, very shrewd economic transactions, some financial transactions, because of the power of attorney. So it's a very valuable document. People don't really think of it being necessary, that someone else should have the ability to sign my name when necessary. But it truly is. It's right there. It should be at the top of everyone's to-do list.
I suppose if you're working with a couple and they get divorced, there's some ramifications there, eh?
Yeah, there are some very serious ramifications there. The most common that I see occur when a couple gets divorced, and then after the divorce, they do not change certain documents. For example, life insurance. The divorce is very difficult to go through. It's emotional most of the time, but when the divorce is over and done and completed, people want to just relax a little bit and have a little rest and relaxation and recover from the impact of the divorce, depending upon either side of whether you made the decision or the decision was made for you by your spouse. And people frequently forget to change a life insurance policy. Well, if the spouse, who is now the former spouse, remains designated as the beneficiary, that's exactly what's going to happen upon a death, even though that may not be your intention. It happens way too often, where a divorced spouse then becomes the beneficiary of someone's life insurance policy that should have been changed at the conclusion of the divorce.
Yeah, so something definitely to keep in mind. What's the most common question you get, Steve?
In addition to fees, obviously.
Yeah, right.
And honestly, I tell all of my clients that at the end of our first consultation, or depending upon how long our consultation goes, the latest will be at the end of our second consultation, I will always quote a flat fee, a specific dollar amount, to my clients so they know exactly how much money they're spending. And probably the most common question I am asked is, after I quote my flat fee, they ask me inevitably, will you do this on an hourly basis, an hourly charge? And I have, for the last 25 years, always replied to that. I look at them and I kind of laugh a little bit because I can't help it. And I always say, I will if you really want me to, but I'm going to tell you right now, if I do this on an hourly basis, I win, you lose. You don't want me to do that. The flat fee arrangement is much more logical, and once you have gone through the process, of doing the planning and so forth, and from my side of the table, you realize that the value and the need of what you must put into the estate plan for the benefit of your client, and you come to the conclusion of what is a fair and equitable but still profitable fee arrangement for the client, and it does really work. I mean, I would say after that, the next most common questions would be, who do you recommend and what are the qualifications I should be looking for an executor or trustee or a guardian?
Mm-hmm.
And for an executor, I always remind my clients that the finalization of the estate, hopefully, unless it's a very large estate, I'm talking more than $4 or $5 million, the finalization of the estate will last maybe a year and a half, maybe. So we're looking for someone with common sense. Does not have to be an attorney, doesn't have to be anyone with financial background, but someone who will be able to realize something is wrong here. I need to speak to somebody about this. So they're going to go to another attorney. They're going to say, what's going on with this whole thing? Just common sense. For a trustee, we're talking about a person who has good, because now we're talking about the person in charge of your finances for the benefit of most likely a child. And we're talking about someone who will have good financial acumen, will be able to turn around and make prudent and intelligent, common sense decisions in the world of finance. And a guardian, I think, is self-explanatory in that we're talking about the person that will raise your child for you, or an individual for you, in the situation where you are no longer available to raise that child. So you want a person with parenting skills. Those are my most common questions.
Now, my next question is, what should we look for in an estate planning attorney? And there's two things I've noticed talking with you. It's A, you're very passionate about what you do. You love what you're doing. And B, you really get to know your clients and you get to be friends with them. Is there anything else we should be looking for?
I think you just hit the nail right on the head just then. I think the most important thing in choosing your estate planner is looking for someone that will be much more concerned or equally as concerned about you, the individual, and what your desires are, and then blend that with what we as a professional can do and what documents we can create to implement your will and your desires so that, in fact, they do occur. And it's very, very doable. Once we get through the red tape and the rigmarole and the Internal Revenue Code sections and so forth, you just have to, once we learn where you are coming from, what is in your heart and your head, and what you can verbalize to me, then we can accomplish really what we need to do. And that's what I try to do as your estate planner.
Our guest today is Steve Tarta with Tarta Law in Bergen County, New Jersey, and Steve's an estate planning attorney. Steve, how can we reach you?
In today's world, the most common way of reaching me is by email at startalaw, that's one word, .com. Of course, by telephone at 201-444-8448. And I do have a website that is frequently utilized, and that is tartalaw.com, tartalaw.com.
Hey, Steve, thanks for being our guest today.
My pleasure. Thank you very much. I appreciated it. I enjoyed it so much.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.